All right. Thank you all so much for joining us today. We will absolutely make sure that this webinar is available and recorded for those who aren't able to join us live today. But I'll go ahead and get started. My name is Megan Wright, and I am with másLabor. We are the nation's largest H2 services provider. And we are incredibly excited to be partnering with AgAmerica for this webinar following National Agricultural Week. And so we are going to take some time and really dive into the H-2A program specifically. I definitely want to make sure that we save time for questions at the end. We were able to get quite a good handful of questions in advance, so thank you to those of you who submitted those. So we'll definitely get those answered, but then please, throughout this presentation, please type in questions into the chat box, and then we'll certainly make sure that we get those answered before we finish. But outside of questions, we will be walking through the H-2A program in general. So that means a little bit of history. That means what are the program requirements? What are some considerations that you should keep absolutely top of mind from an operation standpoint prior to entering in? We'll definitely talk about the filing process and the timeline. Again, a lot of things to be considered from a compliance perspective, but then also, okay, well, when should I even get started with this H-2A program? And then we'll talk a little bit about what we call crossover strategies. We're really seeing more and more operations use both programs simultaneously, again, if it's a fit for your operation. And then we'll spend the last few minutes going over current events. It's been a busy couple of years within the H-2A program, but even the past couple of months, we've really seen some shifts and some potential new rules that might ultimately affect how users use the program. So we'll definitely want to cover that. And then, as I mentioned, certainly saving time for questions at the end. So that being said, where did the H-2A program even come from? So we actually have to think back to 1952 with the Immigration and Nationality Act. That's what created this H-2 visa class for all temporary workers. And then fast forward to 1986 with IRCA, that's actually what split the program into two. And for the most part, really what we know of these programs today. So we have H-2A, which is for all temporary and seasonal labor needs from an agricultural perspective. And then we have H-2B, which is also temporary and seasonal, but for all non-agricultural labor needs. So when we think about, okay, well, I'm an agricultural operation, do I qualify? Of course, it's a little bit more nuanced. So we have to think about what are these government agencies looking at to see if you do actually qualify as an agricultural operation. So in terms of H-2A eligibility, we're really needing to satisfy either the FLSA definition or the IRC definition. And those really split into two categories. Are you performing or have a primary agricultural operation? That's really what we think of. Are you planting? Are you harvesting? Are you growing your commodities to maturity on land that you either own, lease, or control? Or are you then still the farmer, but then participating in what's considered a secondary agricultural activity? Are you taking your onions that you grew and now packing them? Are you processing what it is that you grew? Are you transporting your product to market? All of those items, then more of a secondary agricultural component. Then, of course, for H-2B, really anything that does not fit within those two definitions would have to go to the non-ag program, or again, H-2B. So we've talked about the first level of eligibility. Are you agricultural in nature? So now we've got to think about the second layer, program seasonality. Even this is not as cut and dry as it seems. There really are three different ways that you can be considered seasonal for, again, the H-2A program purposes. Number one, is your season tied to a certain time of year? Number two, is it tied to an event or a pattern, like a growing season? Or number three, do you have labor levels, or I should say, do you have a labor need, or is your operation of course all year round? But do you have these peak seasons where your labor levels go far and above your ongoing operation? So again, how can we supplement and really take advantage of that peak labor need with this program? And then we get this question quite a lot. Okay, well, what does temporary actually mean? How long can I have these workers? We'll talk a little bit more about some of these components, but at surface level, per occupation, meaning with the job duties, the sum of all those job duties, and per geography, you can have these workers doing that occupation for up to 10 months out of the year. So as long as we don't tip over the scale in terms of needing that particular occupation in that particular geography, again, at those higher labor levels for more than 10 months, you can qualify. Now we're going to go ahead and go into a lot of the requirements. And so this really is what I like to tell employers, are the big ticket items. These are the things that you absolutely have to keep in mind if you're wanting to consider the H-2A program and how it's ultimately going to affect your operation. So it goes without saying, of course, when we think about the government agencies that approve your application, and we'll get to that process in just a little bit. But Department of Labor is one of those main agencies. They clearly care about the well-being of the U.S. workforce. So again, it goes without saying that we really need to make sure that we're not adversely affecting our domestic workers by participating in this program. So a positive U.S. recruitment process is required when we go through the H-2A program. So ultimately, as an employer, you just need to be aware that if a U.S. worker applies for this role, you absolutely have to interview them. And then if this individual is four things: qualified, willing, available, and able, you must hire that U.S. worker. And you can see there in the second bullet point, the obligation in terms of, well, how long or when do I need to ensure that I am both interviewing this U.S. worker as well as potentially hiring them? In most cases, it's when we get approved in the first part of the filing process, which I'll show you exactly when that happens, all the way through the 50% point of the H-2A contract specifically. So again, quite a lengthy duration that we certainly need to be aware that we are keeping these job opportunities open to U.S. workers, and then certainly hiring if, again, that U.S. worker is qualified, willing, available, and able. The next big piece here, of course, is that employers do need to pay a specific wage for this program. In most cases, you would be paying what is called the AWER. It stands for the Adverse Effect Wage Rate, which is essentially a state-dictated minimum wage specifically for the agricultural industry. And it is determined by the USDA Farm Labor Survey, and it's an aggregate, again, of all of the agricultural jobs for your particular state. Now, you can see at the bottom there in red, there recently was a new wage rule that has caused, in some cases, a lot of confusion, and others just something that really needs to be taken into consideration before you enter into that program. And it is, if your occupation or your job duties that we are ultimately putting into this application, if those job duties fall outside of what Department of Labor deems is the big six, the six agricultural occupational codes, then you would need to pay really what the Bureau of Labor Statistics says is that prevailing wage for that particular occupation. So again, we really do need to take quite a look at what it is we're putting into the job description to then ultimately dictate what wage it is that you're paying. But again, for most cases, it is the AWER, that adverse effect wage rate. And you can see there are some examples of some of the lowest states in the country in terms of the wage rate and the AWER. And then, of course, California, without a big surprise, is the highest this year for 2024. Corresponding employment is really then something that I like to talk about right after the wage rate. Long story short, again, we need to ensure that we're not adversely affecting any domestic workers by participating in this program. And when it comes to corresponding employment, this means that we really need to ensure that if a U.S. or domestic worker is participating or is handling any of the job duties that we have listed out on the job order or the H-2A application, that they too are entitled to the same terms and benefits as the H-2A workers. In most cases, again, this comes down to the wage rate. So if you have a U.S. worker, regardless of tenure or skill level, if they are sharing any of the job duties that, again, we have put on the H-2A job order, they are entitled to whether it is that AWR or maybe it's a higher wage if we fall outside of the 6 agricultural occupations. But we really need to ensure, again, that we're protecting our domestic workers. And so that's why you notice there in the best practices, we really want to ensure that we're putting a lot of thought, again, into that job description. We certainly want to make sure that our H-2A workers are as efficient and effective as possible and are able to help out in as many ways as is beneficial for your operation. But we also don't necessarily want to open the door so wide that now all of our domestic workers, let's say maybe high school students that come in to help you over the summer, are now scooped up into corresponding employment. Housing is what we have seen in recent times, as you can imagine, is one of the biggest barriers of entry right now, just with the housing market being so tight. But in H-2A, as an employer, you do have to provide housing not only free of charge, but it also needs to be inspected by the state. And so when you see the SWA there, that's the State Workforce Agency. So again, this is part of one of the first approval processes as we go through the state. They do need to ensure that your house is meeting those minimum requirements, which we can certainly send a checklist and let you know exactly what that is. But more importantly, that it is safe and that it is approved for housing for the full number of requested workers. So you can see there, of course, that our best practice is definitely try and get your housing in line as soon as possible because we really do see that it's the number one source of delay when we're going through this overall approval process. The next biggest piece, of course, is travel. So as an employer, you are responsible for both inbound and outbound transportation. So that means getting the workers from their home through the consular process and then ultimately to your operation and then back home again at the end of the contract. You'll notice there in that second bullet point, we have to also be aware of when we're reimbursing the worker for these out-of-pocket travel costs if we did not pay in advance. The regulations state that we have to just reimburse by the 50% point within the contract. But we have to keep in mind that due to FLSA regulations, those travel costs ultimately are deducted from the H-2A workers' paychecks. And especially in the beginning, we need to make sure that they're not falling below minimum wage if we were to deduct that out. So it's certainly our best practice to try and make sure that we are reimbursing workers for this inbound travel, ideally within the first pay period or the first work week. And then again, of course, making sure that we're reimbursing for outbound at the end of the contract. And then we do get this question a lot, so I wanted to include it here. You're not responsible as the employer for outbound travel if a worker either abandons the job or is terminated for a lawful job-related reason. This is something that we'll talk a little bit more about when we get to our current events and our latest notice of proposed rulemaking. But prohibitive fees are something that have absolutely existed in the program previously, but something that these agencies are going to start paying even more close attention to. So just please note that it is absolutely unlawful to solicit or receive any fees from workers, again, either directly or indirectly. So even if a worker pays a fee unbeknownst to you as the employer, you could potentially be on the hook for not only reimbursing them, but also reporting that violation to CIS. And it's also really important that we are documenting this and ultimately having workers sign prohibitive fees agreements to ultimately try and protect both parties there. Some other items before we get into the filing process and the timeline to keep in mind is that you, as the employer, are responsible for also paying for their visa. So, their machine readable visa or an MRV fee did go up this past year, just $15 to now $205. So, keep in mind that you would be required to pay for that machine readable visa as well as the border crossing fee, which is $10 per worker. You are not responsible for any passport fees. So again, if you have particular workers in mind, definitely make sure that they have a valid passport when it's time for us to go through this process. Something else that we get asked all the time, what if I can't find a housing solution that has a kitchen facility, which is one of the key points in terms of the inspection process? Well, that's fine. Maybe you actually need to use a hotel or a motel one of your first years into the program. Again, if you don't have another housing solution and there is not an ample kitchen facility, you would then be responsible for providing 3 meals a day, and that is physically furnishing those meals. But you would be at least able to deduct up to the federal subsistence level, which this year is $15.88 per worker per day. And then the last piece here, we talked about inbound and outbound travel, but also important to keep in mind that you are also needing to provide transportation to and from work each day, as well as at least once a week to go into town to do banking, groceries, that type of thing. So now into the filing process and timeline. So I'll walk through each of these key pieces, but this is sort of the overarching snapshot. We really do recommend, if at all possible, to start your H-2A process at least 120 days in advance. That is what we have seen to be best practice, and it just really sets everything up for smooth sailing. In theory, the absolute earliest that you can physically start your paperwork process is 75 days in advance, and you would start with the state workforce agency. In some instances, if you are a first-time program user, so maybe you're on the call today and you really do want to get started in this 24 growing season, that is fine. There is an exemption called an emergency filing. Ultimately, all it is it just allows us to expedite the process and sort of squishing both Department of Labor and the state workforce agency together or filing with them simultaneously. That can take that process down to as little as 45 days. So again, ideally, we're getting started 120 days in advance. If that's not a possibility, that's fine. Normal filing process starts 75 days in advance of your start date. Or if you are trying to go as quickly as possible and you have not used the H-2A program at least within the past calendar year, you can do an emergency filing, which again is 45 days is the absolute sort of quickest we could turn that around. Goes without saying, all of those program requirements that we talked about would certainly need to be in line and ready to go to make sure that we don't slow the process down. So taking a deep dive into each of these steps just a little bit more, when we say we're filing with the state, you are actually filing the ETA Form 790. And again, we can't do this any earlier than 75 days, but the absolute latest without derailing the overall timeline is 60 days before you would want your workers to start. Goes without saying, sooner the better. And so it's our best practice that really trying to file before or at that 65th day, again, sets yourself up for on-time worker arrival. And again, we do this through the state workforce agency. And then that last bullet point, again, as I mentioned, U.S. recruitment is such a big piece of this overall process. So just know that when the state approves your job order, this opens up your intrastate recruitment period. Then, of course, we'd move on to Department of Labor with your 9142. And again, we're not able to do this any later than 45 days before your start date. And this in turn then, of course, opens your interstate recruitment period following the Department of Labor acceptance. Then we'd move on to CIS, so U.S. Citizen and Immigration Services. We are filing the visa petition, your I-129, and we do this just immediately following the labor certification from Department of Labor. And ultimately, it's important to note, especially as we get to some of the current events, when we look through USCIS's newest new rule that came out and some of their increased fees. It's important to note that for the most part, H-2A petitions are unnamed, meaning that we don't specifically identify workers. Even if we know who we're bringing, we keep this unnamed just to help with logistics as well as cut down on some of the paperwork. If we ever needed to do a transfer or an extension, which I know is a question that will get answered here at the end, those do in fact have to be a named petition and are subject to additional scrutiny, and we'll see how that ultimately is affected with the new CIS rule. And then, of course, after the petition approval, the U.S. consulate gets involved for interviews for the worker specifically. And again, the exact process varies by country and consulate, but we really do recommend to try and have what we call worker facilitators, or at least an agent to assist. It can be a bit of a daunting process for workers, especially if it's their first time. But just know, of course, going to the consulate, getting the MRV into the passport, of course, is that last step. And so I did mention at the beginning that we are seeing more and more employers ultimately utilize what we call either a crossover strategy or really participating in both programs simultaneously. The industry, if you will, that we're seeing this happen the most would be more of the green industry. So thinking of your nursery greenhouse operations coupled with landscaping. So maybe you are a landscaper that has been utilizing the H-2B program, but now you're starting your own greenhouse growing operation. Maybe you need to then supplement, use H-2A on the growing side of things to alleviate some of the pressure that you might have been facing with H-2B and the cap. The elephant in the room, of course, is that the H-2B program is a capped program, meaning that there are a finite number of visas made available every government fiscal year. But again, so we're really seeing that within the green industry, landscapers are starting their own growing operations, as there's a bit of a gray area involved, as installation is ultimately permissible on the H-2A side. So it's important to note that an H-2A worker is able to do anything that is incident to or in support of the growing operation up to the first point of sale. So again, if you grew, let's say, the boxwood to maturity, in theory, that H-2A worker would also be able to install that, as long as, again, you grew that product to maturity. And then we would certainly want any of these ancillary job duties like installation to be secondary to the growing job duties as a whole. Um, Another way that we're really seeing this is as packing or transportation becomes harder and harder to come by. We've seen a lot of employers really open up maybe their packing or processing facility, maybe their transportation services, opening those up to third-party growers. And ultimately, in order to be eligible for H-2A to begin with, you do have to account for at least the majority of the product on hand, especially if these operations are taking place off of the farm. So let's say you do have a packing house, but you pack other farmers' commodities. That might be a situation where we need to look to the H-2B program, the non-ag program. Even if you're packing what's considered an agricultural commodity, if you did not grow it, that is considered outside product. And the last piece that I'll just say, again, while it is absolutely permissible to participate in both programs at the same time, There cannot be any overlap in terms of the job duties. So there cannot be a job duty on both the H-2A and H-2B job order. They need to be kept wholly distinct. I'm going to go ahead and move into some of the current events that we're seeing because it certainly is fascinating to kind of keep a finger on the pulse of really what's happening for the most part in DC and ultimately how this affects the program as well as the government agencies. And so I'm sure you've all heard that we had several continuing resolutions to try and keep the government funded. We were absolutely biting our nails there at the 11th hour on Friday, really into early hours on Saturday, to keep the government funded. And so that did go through the $1.2 trillion. But it's important to note that Department of Labor is fully government funded, meaning it's not a fee-based agency like CIS is. So if the government were to shut down all paperwork processing, and again, DOL is one of those first agencies that we have to get through, would have shut down. And so that would have caused quite a backlog, especially with the H-2B program and the timing in terms of how that process works. So we were very thankful that that did not happen. When we think about, again, the government fiscal year, which runs October 1st through September 30th, so FY23 is our last full year of data, the H-2A program brought in over 380,000 H-2A workers last year. So it very clearly is a necessary program. And so when we think about DC, I always recommend for growers, if at all possible, to ever do a fly-in and meet with congressional members. If not, to continue sending letters. It is just so important that these folks in DC understand the necessity of this program and how it ultimately is keeping your business, an American business, in operation. And then when we think about, okay, well, who's using the program? For the most part, it is what we would call a fixed site grower, meaning that the farmer themselves is going through the process, meaning that they are hiring these workers directly. Then, of course, it comes down to labor contractors. Maybe you are someone who brings in these workers for your business and then legally subcontracts them out, again, through the farm labor contractor process. Or we're also seeing more and more ag associations enter into the picture due to one of the more recent program rules. It changed what was called joint employment. So the sharing of workers got a little bit more tricky. And so we are seeing an uptick in the number of associations that join because it allows for a little bit more flexibility within that process. And so I do apologize if this is really tiny on your end. Again, we will certainly make this presentation available. But this is the latest USCIS final rule that came out, and they did increase the fees that are involved. Again, CIS is a fee-based agency, meaning that we do pay for them to process the paperwork, specifically here in this case for the H-2A and H-2B programs. So we did see an increase in terms of the petition, an additional increase if we do have to do a named petition, which again is any time that we do a transfer or an extension. And then more importantly, there is a new asylum program that CIS has introduced. So now employers are going to help fund that asylum program as well. Now, it's important to note that there are some reduced fees for what's considered a small employer, which is an operation with 25 or fewer full-time equivalent employees. Or, of course, if you are a 501c3 nonprofit, you also have reduced fees as well. But the asterisk there is just this past week, there was a federal district court in Colorado that actually filed a lawsuit to try and halt the new rule from taking effect. As it stands right now, this goes into effect this next week on April 1st. So we will certainly keep an eye on that. And if there are any changes or reductions, or at least, again, a halt to that new program rule, because it did certainly increase these costs across the board. I won't go too far into the weeds, but as I alluded to, again, there are two notices of proposed rulemaking, one from Department of Labor and one subsequently from Homeland Security. Ultimately, here it's gone through the APA or the Administrative Procedures Act. So while it was introduced as, again, a notice of proposed rulemaking back in September, and it has gone through the comment period, we are now feeling as though these final rules may be imminent. And so when it comes to Department of Labor's NPRM, it really does bolster a lot of worker protections as well as what they consider program and integrity. So really making sure that the rule is dramatically expanding worker protections, and ultimately in I I guess an easy way of saying it is that increasing union influence as well. So those kind of are the two main pieces there, as well as potentially limiting an employer's ability to terminate workers for cause, which again is why it's so important to always make sure that you have someone in your corner, potentially like an agent, to keep up on all of these new rules and make sure that you are staying in compliance, because certainly by participating in these programs as an employer, you do want to do the right thing. You are certainly caring about workers. And so we just want to make sure that in turn, you as an employer also get some protection as well. When we think then about the Homeland Security NPRM, this is a little bit more in terms of, again, ensuring of that we're not seeing those prohibited fee agreements, and just really back to that compliance piece, making sure that we are protecting both you as the employer and the worker. It also expands the ability or the agency's authority to conduct post-approval audits. So another agency entity that would be allowed to audit your operation. But at least with Homeland Security's new rule, there are a couple of positives that we're seeing there. Number one, workers would be allowed to begin work immediately following the filing of a transfer or extension petition, which normally there was a pretty decent gap there. It also eliminates the Homeland Security approved countries list. Right now, as it stands, each year Homeland Security publishes a list of countries that are eligible to participate by way of workers eligible to come into the US on an H-2 visa. For example, we have some growers, some H-2A employers that would really like to bring workers in from the Philippines. But as it stands right now, the Philippines is an approved country on the H-2B side, but not on the H-2A side. So, for example, if this NPRM became a final rule, those employers would be allowed to bring workers in from the Philippines on an H-2A contract. And then lastly, while we talked about the employer being limited to a maximum of 10 months out of the year per occupation and geography, a worker themselves actually is allowed to stay in country up to 3 years as long as they are going from approved contract to approved contract. But as it stands now, when they hit that 3 year mark, they need to go home for at least 90 days to reset the clock. And of course, this NPRM now would reduce that down to 60 days. So, that being said, I did want to ensure that we are saving enough time for questions, as well as discussing anything that might have piqued your interest during this presentation. So, with that, I might go ahead and ask my colleague Emily to read out some of the questions that came through prior to the webinar.
Yep, happy to do so. And it looks like the first question is, how many employees can you request to start with at minimum?
It's a really good question. So, the good news here is that there is no minimum. There is no minimum to entering into the program, nor would there be a minimum, for example, if you wanted to work with us at másLabor. It really just needs to make sense for your operation specifically. So, when you think about your labor needs and what you're looking for, that's what they pay more attention to versus a minimum number of workers.
Right, perfect. And just as a heads up, if anyone currently watching has any extra questions, you can submit them down in the Q&A or the chat section. But we'll continue to run through these ones that are previously submitted. It looks like someone else asked what if you had any details on state to state transfers for farming vegetable productions.
Yeah, it's a really great question. We have a lot of employers that sort of follow a specific commodity up and down the coast, depending on the season. And so I think the most important thing to keep in mind is that, yes, we are limited to what is called an area of intended employment per contract. That is ultimately based on your metropolitan statistical area and what is considered reasonable commute time for your area. So there is, yes, a limited geography that we can squish, if you will, onto one petition. And so if, let's say, you had different geographic areas, each area would have to be approved in this overall process. And then, as we talked about doing a worker transfer, that is definitely something that you can do. And so we would transfer the workers from approved contract to approved contract. But I think the biggest thing here to keep in mind is that really is what I would consider a one and done situation. The approval process takes a little bit of time since it is an additional paperwork administrative process that we have to do. So it's not like you can have workers go from one state and then back again and then over here and then over there week to week to week. It would be more again following that particular season from state to state and from approved contract to approved contract.
All right. And then someone else asks if they were ready or interested to getting started today, what would be the first step to signing up? Where should they go? Should they look for?
I would say contact my information conveniently is right there on the screen. So definitely reaching out to me. Then when we think about those minimum requirements, definitely thinking about housing. If you have a housing solution in mind, which again, we can certainly talk through some ways to be creative together, but reaching out to me would be the absolute first step. And again, if you still needed workers this season, we could turn that around in as little as 45 days.
All right. And then someone asked if they hire H-2A workers for 1 year, is it possible to get those same workers the next year?
Yes, I would say that is definitely the beauty of the program or the goal of the program, if you will, is that you really are creating a crew and a foundation of workers. Some of our longest standing clients that we've actually worked with for over 20 years are onto their third generation of the same family. So it really creates an amazing work environment. And yes, that is definitely something you can do, and certainly what we would hope would happen just by using this program.
Perfect. And then we have a more specific question. Someone had asked, can we qualify for H-2A if we are grazing solar sites 9 months of the year and then bring sheep flocks back to home to farm?
So it is a really good question. It's a little bit complicated. What we have to think back to is what are these workers ultimately supporting? And at the end of the day, again, in order to be eligible, we have to be an agricultural operation. And so we have to think about, okay, what business model are we supporting? So if you were a actual sheep farmer and you were, again, your main business model is the care and raising of the sheep as livestock, that absolutely qualifies as H-2A. But if your main business model is generating revenue by just grazing on third-party solar farms, that does get a little bit gray. So what I would say first and foremost is that we would want you to definitely still have a farming operation, again, that is based on the care and raising of the sheep. Then kind of subject to that, you do have to either own, lease, or control the work sites where this is taking place. If not, we would have to go down a farm labor contractor path, which is a little bit tricky because even though it's called a solar farm, that's not necessarily a farming location in and of itself. So I would say I would work on having a lease in place with that particular solar farm. And then, yes, you would then be able to graze the sheep on the solar farms and sort of move them in and out as long as you lease the land. And that ultimately your main operation here and what these workers are ultimately supporting is the care and raising of your livestock.
All right. And then it looks like we got another question. Would an aquaculture business qualify?
Yes, it would. So, really great question. We work with oyster farms, we work with catfish operations, anything that, again, is as long as you are growing that commodity to maturity. And again, you own, lease, or control the land. So, for example, we work with some operations that are in the Chesapeake Bay. So, they have a little bit of a lease, even though it's open water. But that answer is yes, as long as then we can also prove seasonality. Sometimes, let's say with a aquaculture, let's take catfish for example, those lines can be a little bit blurred depending on your geography in terms of seasonality. So again, we just would really have to be able to prove that we have a need of 10 months or less for that particular occupation.
All right. And then it looks like someone else has asked, they have a restaurant and they're looking for 60 workers. How do they get started? What do they need to do?
So it's a really good question. So since a restaurant is, of course, not considered an agricultural operation, we would have to look to the H-2B program, which again, that is certainly fine. But the number one eligibility requirement for that program too is, are you seasonal? Sometimes restaurants can have a little bit of a harder time proving that, unless maybe you're in more of a touristy destination, or again, we can at least prove that whether it's sales or payroll or maybe even your orders drastically reduced for at least 2 months out of the year. I would say that if that answer is yes, if we can prove seasonality, please reach out to us right away because the H-2B process is a lot longer and a little bit more complicated because, as I mentioned, it is a capped program. So we do have to play the game a little bit more, if you will, in terms of timing.
And then we also have a question in terms of housing, what are the minimum requirements? If I have a property that's on my own property, would that work? Or is there anything that I need to be looking out for?
It's a really good question. If you happen to be lucky enough to have a housing operation on site, that's fantastic. I think it is important to note that while this is a federal program, we do still have to abide by state regulations, and in some cases, when it comes to housing, local zoning as well. So if you already have a housing situation on site, that's fantastic. I can again send you the specific housing checklist if you would like to send me an email. That way I can send it to you, but very, very surface level. Each individual needs a minimum of 50 square feet of personal space. Ceilings need to be 7 foot tall. There need to be ample windows with screens, some more compliance-based things. Of course, if you're on a well, the water would need to be tested. But just reach out to me and I can send you that checklist. But again, if it's on site, that's fantastic.
All right. And then it looks like we have another question. So he owns a meat processing company from harvest of the animal to finished product. He assumes his only option would be H-2B versus the H-2A program, even though they are in the quote unquote agriculture industry. What
Yep.
would be your answer to that?
Yep, you are correct. And so kind of the subtext of the regulations is yes, these workers can do anything that is in support of or instant to the growing operation. But if you did not raise that animal to maturity, and the kind of asterisk here is up until the product, I guess I should, another way of saying is the product has to remain in its organic, unmanufactured state. So unfortunately, processing it takes it from the animal to, of course, meat. So yes, Titus, you could, in theory, start a farm, but in all honesty, anything to do on the processing side does take it from, whether it was a chicken or a pig or whatever it was initially. If you're taking it from a chicken into chicken breast, unfortunately, it's not considered the same thing. So meat processing, yes, would be H-2B, but again, we can certainly help you navigate that.
All right. And it looks like that is about it for questions. If we do have any more, obviously Megan's contact information is up there. But Megan, I'll let you close it out.
All right. Yes. Thank you again so much for participation and definitely submitting those questions. It is always so nice to answer things that are pertinent to your individual operations. So please, if you have anything else or you didn't feel the need to ask during this webinar today, just reach out. That is definitely what I do for my role is get into the nitty gritty again for your operation specifically and make sure that we think through if this would ultimately be a good fit for you. But yes, with that being said, again, thank you all so much. Please reach out with questions, and we look forward to continuing our partnership with AgAmerica. Thank you all so much.